Damien, hello.
Hello, good to see you again.
Welcome to episode 2 of our podcast.
Really thrilled. I've been talking to lots of people that are very excited to hear us talk, which is enlightening and also daunting to be able to think that so many people are listening. But really, anytime I get to talk with Horace Wu is a good day.
Likewise, Damien. And, I jokingly never pay you any compliments in public because I think you receive enough of it.
Too much. My wife is thankful for that. Yeah, that you don't compliment me too much.
So I'm going to take back everything I say. I'm scratching all of that and we're starting again.
It's a drudgery to talk to each other. Yes.
Welcome to episode 2 of our podcast. We've been kind of messaging offline about this topic, and it's called The Great Convergence of 2024. Now, of course, it's a very grandiose title, and it was deliberately, ironically grandiose. But underneath it, I think there's a real trend that's happening right now, and I want to share it with you. And in fact, I thought we were onto something quite novel until Richard Tromans published an article like 2 weeks ago that talks about the Great Convergence. So I'm a little bit miffed at Richard, but we're going to put our own spin on this. And we're going to talk not just about the observation of the Great Convergence, but I think what we can do about it. So Damien, I won't dive into this in any great depth just yet, but I want to kind of throw it out to you to see, like, what are you seeing out there in terms of like products and what's happening in terms of convergence of features?
So there's the convergence of the foundational models. That is, OpenAI's and Anthropic and Gemini, that generally if one asks a particular prompt or question of any one of those, the outputs of all of them seem to be converging quite nicely, or I guess poorly, depending on whether you like convergence or not. But it seems like the foundational models are, the space race of foundational models is reaching a point that there's parity largely between all of them. So there's the convergence of the foundational models. And then there's also kind of convergence of the tools that are using those foundational models. So legal tech tools, for example, that are saying, what can we do with the foundational models to be able to do legal workflows and legal tasks and that kind of thing. So I think there's a bit of convergence around those as well, partially because there are only so many workflows for legal work, right? So if I'm a litigator and I want to analyze a complaint, that's a workflow, right? If I want to be able to create a deposition, that is a workflow. So there is largely that convergence is just because this is what lawyers do. And if you catalog all the workflows and all the tasks within those workflows, there's only so many workflows and tasks to do. So I'd say that there's probably two ways to look at the convergence. One is with the foundational models and one was with workflows and tasks. But I'd be interested in your thoughts on convergence.
I think you're right. Like I was mainly focused on the convergence of tasks and the utility that legal tech tools are providing. The convergence of the models itself, I'm going to push that off to a little bit later in this conversation because there's a lot of interesting news that's happening right now with OpenAI and all the competitors who are coming up and what OpenAI is doing with its sort of market positioning. But let's park that till later on in this conversation. In terms of the convergence of features of legal tech tools, this is happening in a macro way and a micro way. And what I mean by that is I think there's a lot of players out there who are now trying to become the platform for Gen AI. You have Thomson Reuters and LexisNexis, of course. They want to maintain their dominance as the platforms, but there are also the scale-ups, the startups who are all trying to do the same. So Harvey is a great example of people who are trying to become the platform for Gen AI. Leia is like snapping at their heels. Springbok is there. Gilo, who we previously talked about as well, is there, as well as a lot of players pivoting into the space, like Brighter, turning their no-code platform into a sort of Gen AI platform. So everyone's kind of like doing this macro thing of, I want to be able to offer Gen AI in some broad scoped way. And at a micro level, I think everyone's releasing features powered by Gen AI that look and feel very similar. So tools like, hey, we're going to have a table that allows you to have specific extraction points in data like Habir does. And iManage is releasing the same thing. And there are many, many others who are doing this table style format. And then there are people who are doing workflows, like you said, for litigation, for transactional. In the transactional space, recently, there are a few people who've released issues list creators. Like you put in a document and it creates for you an issues list. And it creates an ecosystem where I think buyers are inundated with lots and lots of these sorts of things that look and feel the same. And on another point of convergence, beyond just features, there's a sort of messaging convergence. Everyone's saying they do the same things. And so it's a really interesting trend, and it's happened in other economies and other sort of markets as well. So I think this is something people have to contend with for the next, I would say, 12 to 36 months. Everyone's going to say and do the same things. And how do you survive in a market like that?
That's really astute. And this kind of goes back to, this is my favorite analogy about oil, that data is oil and you have public oil and private oil. But the private oil is, your internal contracts, the internal settlement agreements, and then public oil is cases, statutes, and regulations. So if you don't have the cases, the statutes, and regulations, of course, you're going to converge on the private oil side of it. So to be able to say, here's all the things you can extract from the issues for the complaint, or for a merger agreement. Here's all of the issues that can come from that merger agreement, because all you have is the private oil. But if you have public oil, then you could be able to say, does this merger agreement violate EU antitrust law? Or does this particular contract, is there a case that might affect this contract? Or for litigation, give me the case that was just decided yesterday as to be able to do this. So I would say that there is a convergence on the private oil side if you don't have public oil. And really the differentiation is, do you have the cases, the statutes, the regulations, and that kind of thing? Because if you do, you can go beyond the convergence and actually provide value that is beyond just extracting what the large language model thinks you can extract from the document.
In a way, what you're kind of saying is the circumstances, the available resources is pushing people to flow in a certain way. And that is leading to the convergence because, well, water flows downhill. There's only one way to go. And what is going to happen when people realize, okay, we're all in the same competitive landscape now. We're all competing against each other. Let's think about this from several perspectives. From the vendor's perspective, like how do we survive in a landscape like that? From a customer's perspective, how do you choose the right thing to buy in a landscape like that, both for the short term and the long term? So Damien, I'll throw to you first. As a vendor, how would you survive the onslaught of everyone claiming to offer the exact same capabilities?
I think the real question is, number one, data. Do you have the public oil or not? And number two, what are you doing with the data you have? So for example, and this goes to the product analogy that you remember, you have oil, you refine the oil, you take that refined oil, make it into a product. Say if it's plastic, is it a toy? Is it a water bottle, right? You have to decide what the product is, and then you have to get it to market. So I think the differentiator, number one, what oil do you have? That's differentiator number one. Number two, what are you doing with that oil? What is the product? So are you creating all the workflows that are necessary for that particular lawyer for those particular tasks? And then number three, how are you getting it to market? And really part of the go to market is, and this kind of relates to product, is it dead simple to use? Because lawyers need things that are dead simple. Steve Jobs said the best user interface is no user interface. And I agree with him. And also, Sam Altman was asked on stage, what do you think of the ascendance of prompt engineering as a field? And he said, I hope that's not a thing in a year, because if I'm doing my job correctly, you won't have to be a prompt engineer. All you have to do is ask a question and I'll give you an answer. So I think with both of those, what kind of user experience are you giving to the user? So for example, with what I'm building with VLEX, you merely upload a PDF and we give you hundreds of pages of really good things. The best user interface is no user interface. And, all you have to do is upload a PDF and you get really good high quality information. So to recap, what data do you have? What products are you making? Are you making it dead simple? And then do you trust these people to be around next year, because of course, with procurement being as it is with law firms, you don't want to procure with a company that might go away next year, or that might get eaten up by a competitor that you don't want. So I think those are the differentiators for, maybe to be able to differentiate each vendor against consolidation. What do you think? What do you think on your side?
Well, I'm going to play on your analogy with oil and kind of talk about the process of going from crude oil to plastic toys that you might sell in the marketplace. And I think legal tech is a lot like that. And in fact, every manufacturing and production, the work chain is like that. Depending on where a vendor is playing in the market, whether they're on the data side, whether they are on the product creation side, whether they're like pressing molds into plastic things, like there are different ways of differentiating. And what you've kind of described is where you are across the entire vertical, right? Where you vertically integrated from extracting the oil to all the way to pushing plastic toys in front of the customers. Most vendors, I don't think, have that breadth. It's simply a matter of neither do you have the experience nor the capital to establish that from day one. So if you look at kind of where you are in the manufacturing process, there are points that you can differentiate on. You can differentiate on how efficient you are. You can differentiate on how well do you produce something that your customers actually need. Like simple things, like let's take the oil analogy, whether you're producing something that's 80% pure versus 85% pure, that's your differentiator. If you're going down the line to like making plastic toys, is it a hard plastic? Is it a soft plastic? Is it shaped in the right way? Like all of those things are differentiators. And it all comes back to, are you listening to what your customers are telling you? And I think like people who are jumping on a bandwagon by going, hey, I've released a feature that does X because my competitor has released a feature that does X, is not really listening to what their customers want. They're listening to what their competitors are doing. And maybe that's a strategy that keeps you irrelevant, like, keeps up with the Joneses, but it's not ultimately, I think, going to give you longevity.
I think that's right, because of course, any copycat of a competitor's feature has not done the essential user research, I think is where you're going, to be able to say, yes, I see the user interface on the podcast that the person did, right? But they haven't done the hard work of going to the user and being able to say, what do you really need from this feature? I guess maybe they have, maybe they haven't. But if you don't do that user research, then yes, you're merely copying the output without knowing the underlying causes. And of course, this goes to the fact that with any product, you don't see the underlying prompts that are going on in the background. Mm-hmm. So with the demo, you're not going to see for a VLEX demo, you're not going to see the 25 prompts that we have in the background. Those 25 prompts reflect our user experience. That is, we've talked to users. I've been a litigator sitting in those shoes. You've been a transactional lawyer sitting in those shoes. So those 25 prompts in the background reflect hard-won user experience that you don't see on the front end with those demos. So if you're merely copying the yes, here's some magic of a thing coming on the screen, it's hard to be able to replicate the hard-won user experience. What do you think of
that? You remind me of something. Something happened this week, which was for me a new experience. And that was one of our hopefully very soon customers shared with us a video where they discussed something internally. And they shared that with us and said, okay, here's our recording, take it away, do something with this. And that recording revealed so much more than a customer to vendor conversation would, because in that sort of customer to vendor conversation, there's always a veneer of like, well, we have to maintain the decorum. We have to maintain some sort of confidentiality, some sort of like shield and guard. But an internal conversation that's recorded and then shared removes all those guards. You really get to see what does a customer want in their words, not in words that are dressed up for a vendor, not in words that are dressed up in and transformed. And for me, that was a new experience because, even though I've been sitting in these rooms and talking to customers, it's never the same as if I am actually a fly on the wall. So that was a new experience for me. And what it kind of triggered in my mind was there's a level of trust that a vendor can earn. And when you earn that level of trust with your customers and they tell you all these secrets and these things that really make a difference, that's when you can create a product that address actual needs. So I think earning that trust is a differentiator for vendors.
I agree. And you and I have talked about that trust. And yeah, trust is really hard to gain and really easy to lose. And so and when I was a litigator, a lawyer, my partner said, trust takes a lifetime. And I guess reputation is what he was saying. A reputation takes a lifetime to earn and can be gone in one moment. And really, as lawyers, our reputation is everything. Our reputation before judges, our reputation for clients. If we lose our reputation, we lose everything. So I think it's probably the same to be said for vendors. That is, one could imagine that you gain a pretty good reputation, but then if the emperor has no clothes, that is gone in an instant. So I agree that customers need to trust their vendors and that trust needs to be hard won. Something else I've been thinking about with your user experience example is I've been toying with a large academic institution. I guess I'll say the name. So University of Minnesota, Dan Schwartz has done something his study number one was to say, how well did the large language models do on exams? And then study number two is to say, how well did students using large language models do versus students that don't use large language models? And then study number three, he's kind of going to do a John Henry where he's going to have partners analyzing outputs from a human and then outputs from a machine plus human and have the partners say which would they like the best. But then maybe study number four, we're maybe talking about a collaboration with the computer science department, where the computer science department is thinking about doing eye tracking studies to be able to say, as they look at Vincent, one of Vincent's features is trust but verify. where you could be able to say, here's the case, and here's non-hallucinated text from that case. So I, as a user, can be able to trust that this is actual non-hallucinated text that answers my question. So what this proposal from the academic institution is maybe we could do eye tracking studies to do heat maps of where the user's eyes are going. Are they actually trusting and verifying the way that they should be trusting and verifying? And the way that my hypothesis is that, of course, if you have the text from that non-hallucinated text, from that non-hallucinated case, of course, the user is going to validate that non-hallucinated text. At least that's a hypothesis. But this eye tracking study would actually validate or invalidate that hypothesis. So having a data-driven way to be able to validate user experience, I think, is something that we don't see much in legal tech. But I'm excited with that possibility. What do you think of, taking users' behavior and quantifying it?
I think that's a brilliant idea. Outside of legal, people do that sort of studies all the time with their customers. There are applications that let you track users' mouse flow on a website, and it tells you kind of what they're clicking on, what they're looking at, etc. And we don't do that often in legal because so much of legal tech is applied in a confidential setting. So law firms will never, ever, ever give us the ability to track what they're doing because we just 1,000 different confidentiality obligations that they have. So the fact you're able to do this as an academic study is incredible. I think that's such an amazing thing.
And really to add on that, my hypothesis too is that one, you're going to trust and verify with our product. And the hypothesis number two is that with competitors, if the friction is very high, if it's painful to trust but verify, if you have to do 3 clicks and then scroll through a 20-page document to trust but verify, my hypothesis is that pain means that you won't actually do it. You won't actually trust but verify. So I guess a companion study, or maybe the same study is, with Vincent, is trust but verify. Are people actually looking at that non-hallucinated text with Vincent? And then number two, are they not going through the pain with our competitors of trusting but verifying? And if those two hypotheses are true, then maybe I'm chasing the right thing.
I think you are. I mean, look, my gut says that's the right way to go. About 6 months ago, I don't know if you know her, Jeannie Patterson, who is a professor in Australia. She and I were having a chat, and I proposed an idea to her, which we were going to study, but then it kind of fell by the wayside. And it was the prevailing format for citing authorities, at least 6 months ago, was to insert little footnotes. As it's generated, it will go to footnote number 5. Here's the citation. And the hypothesis we had was that's actually counterproductive because by having a footnote, by citing some authority, people automatically increase their level of trust without actually looking and clicking on the citation. And the footnote format, that sort of form factor, is counterproductive in the case of generative AI. Now, we never studied this, and I think it'll be a really interesting study to actually see if that's psychologically true. So what you're doing now, I'll be keeping a very close eye on. I want to see kind of how that turns out.
Yeah, that is a very good point. And I've actually found that to bear with Perplexity. I don't know if our listeners or you use Perplexity, but I find that, so I asked Perplexity many questions that I would have otherwise asked Google, where Google gives you 10 blue links. Perplexity actually takes those, the text from those pages and then condenses them into an answer. And within the answer, it gives you footnotes to be able to say, here's the sources for this answer. When I first started using Perplexity, I checked those footnotes religiously, but I trusted the system. It became so good that now I trust it implicitly, and I almost never click on those footnotes because it's so good. So there is a real danger that we as users will trust the machine and implicitly trust the makers of that machine to be really good. And there is a real danger that if Perplexity starts selling advertisements and starts saying that if you advertise with us, then maybe you'll be pushed to the front of those footnotes. And I, as a user, won't actually validate that this is a sponsored footnote link. And then there's a way for enshittification, as we talked about in the previous one. There's a way for this to creep in if we trust the machine too much.
Yeah. Well, look, I don't know how to stop that. I don't think it's...
Well, you and I can build good systems that don't do that.
You mean good systems that don't hallucinate, or good systems that give people...
That give people what they need, that take the user's trust and don't do bad things with the user's trust, and be able to say, yes, we will give you high quality answers. And I guess a way that we can do that, and a way that we do it in our system, is to be able to, we have a many-stage process where we give the initial answer, and then we have a second large language model validate that answer. And then we have a third stage where it gives a third validation of that answer. So you essentially have we talk a lot about agentic AI, and that is a sense the agents that we deterministically do. This isn't an agent deciding to double check or triple check. This is instead us demanding that the agent number 2 check agent number 1 and agent number 3 check agents number 2 and 1. So this kind of essentially in the background, we're trusting and verifying for the user. So this is a way that we can be able to, ensure that you have high quality results in the output.
We tried a similar thing. We found even after this checking, the results were not 100%. So what we did was an Australian client wanted us to go through an agreement and extract out everything that's an obligation and list it out so that their lawyers internally can, it's a corporate, their lawyers internally can decide, okay, how do we comply with these obligations? What are the timelines, etc. And so we got GPT to do a first pass and go, GPT, go and extract out all the obligations and summarize for me what you have to do, summarize the timeline, etc. Now, with the answers, we pass it through Claude, and they say, Claude, pretend you're an academic revising and marking this. And if it's correct, leave it as is. If it's incorrect, provide a better answer. And what we found was the uplift was from about 85-ish to about 93-ish. But you still have that 7% gap where because the language of the contracts was so ambiguous, even humans were like, what does that mean? And the classic case is where it says, hey, blah, 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 semicolon, provided that, semicolon, provided that. Is the second provided that a proviso to the proviso or proviso to the clause itself? Like,
yes.
Nobody knows. So I think ultimately it's a human in the loop part because that 7% gap, you need a human to close.
Yeah, and that proviso to the proviso reminds me of, there's been a lot of talk about we express our ideas in words, that is contracts in words. So you can imagine the proviso to the proviso could be fixed, but if it were provided in code. That is if you could have, you could have the clause in parentheses, and then you could have the embedding clause in the other parentheses, right? So there's a real question as to whether natural language and its ambiguities is maybe better suited to instead use a code to be able to reduce and eliminate those ambiguities on the front end. So I know James Hazard is somebody who has said that we need to have our contract should be in GitHub. That is, this code, and then you could be able to say, I've forked this contract to be able to say these things, and here's the diff between the original and the fork. That's, there's a question as to whether we continue with our linguistic contracts or we go to code-based contracts or code-based litigation, et cetera.
There is a counter argument to that. And this is where the Australian client and I kind of ended up, which was in contracts, the purpose is not necessarily to have the clearest possible drafting. The purpose is to reach the end of a deal and get all parties to the outcome they want. And the provided may actually be there intentionally to keep both parties happy, where one side thinks I've won because I got what I want, and the other party thinks, oh, no, you haven't. And they're going to go move on and sign the contract. And so the ambiguities exist for the clients to both feel good about themselves and then move to a close.
And then maybe 3 years later get in litigation because of that ambiguity. That I, as a contract litigator, would then look at that and say, why was that written so ambiguously? Couldn't they could have just made that clear? And of course, that's the difference between a litigator and a contract lawyer. And I often thought, and you and I have talked about this in the past, I've often thought as a litigator, $1 million or $2 million into this litigation, like if that contract lawyer that wrote that contract had known that he was costing his client $2 million in legal fees to deal with this ambiguity, maybe he or she would have written that contract differently. But who knows, the future, right? You don't know that 2 years from now, that ambiguity that made your clients happy and got the deal done is now leading to this bad thing down the line. And it would be interesting to be able to maybe validate that in a data-driven way, to be able to say, for this clause, as you're drafting the clause, say, this actually showed up in 25 different pieces of litigation. This very ambiguity that's going to make you happy is going to bite you down the line, likely, right? Maybe you want to revise it. So what do you think about that kind of a proactive approach to contracting based on future litigation?
I love the idea of it. I don't know where we'd get the data to actually be able to do this in an accurate way, but I love the idea.
If only you had 1 billion legal documents from around the world of every federal court and 38 state courts, so that you could have that data set.
If only I had the time of 5 data scientists to go and just plow through all of this, right? Which law firm is going to pay us to do that? I wonder. But no, I love the idea of it. A conversation I had with a guy called Professor John Swinson, who's now the Dean of Queensland University in Australia. He told me a story once upon a time, and I don't know if this is confidential. So, John, please tell me if it is. Um, there was a clause that he was instructed to write, and when that contract was signed, it became a precedent. Then the next time the negotiations came around, it was a different GC for the client, and the different GC goes, "Why do we have this? It doesn't make any sense." And John goes, "Well, yeah, but it's there on purpose, and here's the history, and here's the why." And so a lot of times, I think it's not it's not that lawyers in the transactional world don't understand the consequences. It's that the lawyers in the transactional world go, well, given the balance of risks and what people want as outcomes, make an informed decision. And here is where we land.
That pragmatism is something that we as litigators don't often understand. And that kind of pragmatism, I'm going to attribute this to John Scrutato, who's really brilliant. You know he's brilliant.
Yes.
I know he's brilliant. And I think he said it, but if not, I'm attributing this really smart thing to John. But he said, what often as contract negotiators, the other side will include a provision that is unlawful. That is, it's not permitted by law. And he said, I'll leave that in, and I'll essentially concede that, knowing that on the back end, if somebody tries to enforce that, it won't be enforceable because it's not permitted by law. So I, as a contract lawyer, am conceding to have this unlawful thing be put in there, because then that's going to be part of my horse trading. I'll say, sure, okay, I guess we'll do this, knowing, of course, in my mind that it's not going to be enforceable. But then you need to give me this horse, and then I can actually further the negotiation. That was an insight that I, as a litigator, hadn't considered before.
Yeah, and that's when you double check the severance clauses there and go, oh yeah, severance is fine. We're good.
Yeah. It's quite fun, the games we play, right?
Well, look, it's ultimately about serving the best interest of your clients, right? Like as lawyers, you always look at like what is the best thing for the client? What do they want? And can we achieve that? How do we get to that outcome? I realized as we talk about like the best outcome for the clients, we haven't yet spoken about how do law firms, how do corporates, how do customers choose the best technology in a world where there's convergence of features and messaging?
That is maybe the $1 trillion question, certainly $1 billion question. But yeah, I think there's, as convergence happens, of course, a differentiator that OpenAI, Microsoft, Google, Facebook, and Meta are thinking about is agentic behavior. That is, can my agents do things that your agents cannot do? So maybe, you can imagine that's also in legal tech. Everything is, how do we build agentic behavior? Something I've been mulling about that I don't know if you've been thinking about too is there's the LLM agents that everyone is thinking about, to say that, you just give the LLM agent a goal, and then a swarm of agents achieve that goal however they want to achieve it. So that is, we'll call it option one. Option two is more of a human-driven approach to say, I, as this type of lawyer, do this type of workflow with these defined tasks for every single time that I do this workflow and task. So maybe I will then create all of the tasks in a symbolic way, that is, in a way that is deterministic, and then let the large language model complete each of those tasks in a probabilistic way. So this is kind of a, rather than option one, where you have just, let the machine do magical things. Number two, you say, no, there are guardrails to what I as a lawyer do every single time. Because with option one, a lot of bad things can happen. With agentic behavior, maybe they go down a rabbit hole that they shouldn't have gone down, or they get stuck in a loop. There's all sorts of bad things with option one, where with option two, with the more deterministic human-created tasks, then it's going to be consistent because it's deterministic rather than the probabilistic of option one. So I've been thinking a lot about ways that companies can differentiate is to collect all of the option twos that they can. That is to be able to go through all of I am this kind of lawyer providing this kind of workflow with these kinds of tasks, and be able to catalog all of those that they have, and then let the large language models fill in the long tail of the things that I haven't yet cataloged. Yep. And then as that long tail, as users do that long tail with the LLMs, collect that user behavior of those long tails, and then the more frequently done tasks and workflows, add that to the symbolic side. That is, add that to the deterministic side. So now, okay, because users do this, now I'm going to add that to my known knowns list rather than my known unknowns list. But what do you think of that thought of differentiation?
I think that's one thing you can do to differentiate. I don't think that is the only thing you can do to differentiate. And also, separate conversation we'll have another time. You've mentioned a fully agentic approach, a fully autonomous agent approach versus the kind of like scripted workflow approach. There is a third way that we have been exploring, and I'm not going to talk about it just now because it's actually confidential. I'm hoping we can present on this at Oz's skills event in January, and it'll be a lot of fun. There's a third way. When it comes to kind of differentiation, it does depend on what you're offering. What you've described as the sort of LLM agents approach, it works really well if what you're offering is the component in the pipeline that does the logic and the decision making and the complex operations. If what you're offering is a pretty front end that doesn't gel. So I think like in terms of buyers making decisions on who to back and who to buy, I want to leave that to the next episode.
That sounds great. We'll leave our listeners on the edge of their seats.
I am looking forward to it, Damien. And we also haven't spoken about OpenAI, but again, next episode. We just always run out of time.
It's so many fun things to talk about. But yeah, O1 is very exciting. And their dev day 3 days ago, Pablo Arredondo and I were giving a presentation at the Minnesota CLE in person. So we were together. And Pablo was kind enough to say that he was going to go to the OpenAI's dev day, but he instead joined me in Minnesota to be able to talk to a bunch of lawyers. So Pablo, if you're listening, thank you for being such a good sport and to see in person all the cool things that OpenAI just said during dev day.
And I feel like I have to say thank you for all the listeners. Your words of encouragement means a lot to me, and I think to Damien as well. So until next episode, have a lovely rest of your day.
Great. Thanks, everybody. Thanks, Horace.